Yes, absolutely. Feel free to invite everyone. Like I said, it's very casual. We'll have drinks and some appetizers. It's going to start at 5 o'clock. It's the Bar Louie on Park Lane, right off of 75. So yes, open invitation. Feel free to invite whoever you want. And then on August 18th, we have our regular meeting. Jason and Larry Simmons are going to speak. The title of the program is Point Counterpoint. And it is a comparison of looking at bankruptcy versus loan workout in the franchising context. So exciting programs that we have coming up. And then September, we have another happy hour with the, hopefully in connection with the real estate section, discussing negotiation of lease riders and terms that you want to put into franchise agreements with respect to lease provisions during the site selection process. So that programs. Hope to see you at some or preferably all of them. So we're going to go ahead and get started. We each are touching on a different topic, but like I said, we don't have time to cover everything. So just kind of a little bit of a cross section of some highlights of some important cases. And I'm going to let Jason start off. And I have gifts again, so as always, if you participate, you get a gift, and always encourage participation. Can we turn it down? The back? Larry gets mad when you turn it off.
Thanks, Sarah. My name is Jason Bedford. I turned the microphone off. I can talk loud. That thing has a microphone, so hopefully the video will be all right. I'm with Kane Russell Coleman & Logan. I am a bankruptcy attorney, and you're probably thinking, hey, this is a franchise presentation. What's up with the bankruptcy talk? The first two cases I'll talk about are bankruptcy cases, but wouldn't you know it, they touch on franchise issues. We're going to bounce back and forth among our topics today. I think I have about 5 minutes to talk about these cases, so I'm going to try to move pretty quickly so that we don't keep you here. You have your handout. My contribution was the incredibly substantive, just issuing the holding and not skipping past all those facts that we don't worry about. But I'll touch on some of the facts here for you folks who are attending. The first case involves a real estate developer in New Jersey and New York named Donald Trump. You might have heard of him. He's involved in bankruptcy from time to time, and here's a case where he was involved in bankruptcy and franchise issues came up. He and his wife were the licensor of a trademark licensing agreement for the use of the Trump name and brand in New Jersey, Atlantic City casinos and hotels that branded as Trump. He assigned that to an entity called Trump AC, so unfortunately for the entertainment value, Trump, the man, stepped out of the case at that point. But so the key is that the licensor owns that Trump name, and they sued the licensee for apparently not complying with the quality provisions in the licensing agreement to enforce the quality that we all know and expect at a Trump establishment. So in response to that New Jersey state lawsuit, the entity that was sued was the hotel and the casino entity. That entity filed bankruptcy in September of 2014. For those of you that don't know much about bankruptcy, it means that the automatic stay went into place and the state court lawsuit was stayed. They couldn't move forward without seeking relief from the court, which is what they did. They went into bankruptcy court and they said, look, we should have relief, the licensor speaking here, we should have relief from the bankruptcy stay because there's a anti-assignment provision, or there's a assignment provision in this license that says that they are prohibited from assigning it to anyone else. And under a kook of the law, under the bankruptcy code, you have to look at whether the debtor whether it was assignable at all, despite the fact that the debtor has no intention of assigning it, to determine whether the debtor can even assume that licensing agreement. And just to kind of give you some basic vocabulary, that's really the two options of a licensee, is to assume or reject the agreement. So Trump licensors go in and they say, look, these guys can't even assume it. And so we should get relief from the automatic stay for that reason. And this was there's two jurisdictions, hypothetical jurisdictions and actual jurisdictions. This is a hypothetical jurisdiction, and by that they mean we don't care what the debtor says. The debtor's pounding the podium in court and saying, we have no intention of assigning this. We just want to assume it. We're the same guys. We're going to reorganize and be run by the same folks, and we have absolutely no intention of assigning this agreement. Well, they have to hypothetically go through an exercise of saying, is it assignable? Even if you were to assign it in this hypothetical alternate universe, and if we determine that it is not assignable, then you can't even assume it, like I said. So the analysis was under trademark law, under non-bankruptcy law, would you be able to assign this over the objection of the Trumps? And their conclusion is no, you wouldn't, because the identity of a trademark licensee is important to protect the brand. And therefore, because you can't assign it, you can't even assume it. And because you can't assume it, Trump's entitled to relief from the automatic stay to go forward with that lawsuit and basically shut down that license if they have a substantive basis to do that. So it's a big deal in bankruptcy cases involving trademark licensees in these jurisdictions, because maybe that's the most important asset of the bankruptcy estate is that license agreement. And if they can't assume it, then maybe bankruptcy isn't for them, because it's not going to solve anything. The licensor is just going to come in and drop the hammer on the guys. The Cumberland case, second one in your materials, provides basically the other side of that. Remember I was talking in the Trump case about hypothetical jurisdictions. The other side of that coin is actual jurisdictions, where they say, yeah, there's some ambiguity in this section of the bankruptcy code we're all talking about. But debtor, what do you really want to do? Do you want to sign it? No? Well then, why are we talking about whether it's assignable or not? In my opinion, that probably makes a lot more sense to do it that way, but I'll argue the other way if you pay me by the hour. So in the Cumberland case, it was involved a Golden Corral franchise. Franchisee, prior to filing bankruptcy, Golden Corral issued these notices to the franchisee and say, you're not meeting the quality standards. We have this inspection process and there's a point system, and you've failed the point system a number of times. You have an opportunity to cure, and we're going to send that to you, and you better cure it or the franchise agreement gets terminated. They didn't cure within the time, or they got it, but before that cure period ended, the franchisee filed bankruptcy. That's important. Keep that in mind, and I'll touch on that in a minute. What the franchisor went into is they said, look, we're entitled to relief from the automatic stay, and because we're not getting something that bankruptcy lawyers know about, adequate protection. Our interests aren't protected because this franchisee is out there, with a dirty kitchen or whatever else that they failed their inspection process for. And the bankruptcy court looked at it in detail and said, look, there is a point under the franchise agreement where you fail so many times that it's incurable. You hadn't reached that point yet, franchisor. You had told them that they failed twice, and you had provided them an opportunity to cure. They had to fail 3 times in a 12-month period for it to be an incurable default. And so they're saying you basically haven't met your standard under the law. It's an evidentiary issue. You haven't shown that this franchisee is out there ruining your brand and causing you monetary losses. They also looked at, the franchisor made the argument of, look, they can't assign it, so they can't assume it, right? Well, unfortunately for the franchisor, they were in an actual jurisdiction, and the court said, why are you talking about assignment? Nobody's looking to assign this. So they can assume it, so motion to lift the automatic stay denied. I'm gonna jump off because I'm probably over my 5 minutes, but here's a really important point to consider when you're representing either side in this issue, is what if they had an incurable default and it wasn't a notice to cure? Then that would have changed, change in facts would have changed the case entirely. This debtor was smart. They filed within the cure notice period, which arrests that period and allows that franchise agreement to be part of the bankruptcy estate. If that cure period had passed prior to the bankruptcy filing, and the agreement said, you have an opportunity to cure in 5 days. If you don't cure, upon 0 extra notice, the franchise agreement is hereby terminated. and they allowed that period to pass, and they filed 6 days later, then there's no franchise agreement. It's not part of the estate. And so it's a completely different situation from the standpoint of the power a franchisor has in a bankruptcy case. The franchisor in this Golden Corral case was just kind of along for the ride. A franchisor that exercised its rights to terminate the franchise agreement prior to the filing of bankruptcy doesn't have a whole lot to worry about the bankruptcy. The bankruptcy is sort of immaterial because there's no franchise agreement part of that estate. So again, spoke really fast. You're going to see me again in a couple of minutes on non-compete agreements, and thanks.
Okay, Laura, we're going to talk about trademark or privacy?
2015, dun dun dun, the year of the data breach, as I fondly refer to it as now. It seems that there's been a lot in the news about all these different data breach concerns. I know when the FTD update season was happening that everyone was trying to grapple with different provisions that you could put in your franchise agreements that may or may not help isolate the franchisor for some of the franchisees' potential bad acts. So kind of to that point, I want to talk about the case that has everyone up in arms, and that's the FTC versus Wyndham case. Last I checked, I think it's still pending on appeal, but it is an interesting case and it will affect the franchisee-franchisor relationship. So there's two big things going on in the FTC versus Wyndham case. The Wyndham Hotel Group is a franchise system. They have about 90 franchisees in their system. There were several different data breach incidents that happened, and there was about, I think it was a lot of loss. I want to say it was like $6.9 million $10.6 million in fraud loss. There was an exportation of a lot of different personally identifiable information to bad actors in Russia. So it was just, the facts aren't very good. The FTC brought the franchisor in for several different reasons, but what they looked at were some representations that the franchisor made on their website about the data security, and also the fact that they didn't get mad enough at the franchisees for when they found out about the franchisees' bad security standards or some bad acts that they were participating in. You can read the case, it's really interesting, and I recommend that you do so if you're actually interested. But what's really important is the determination of this case will affect the FTC's ability to bring claims against people on cybersecurity issues. The FTC is using this idea of unfairness, and that's how they're bringing these cybersecurity allegations against these big companies. If it's determined that those aren't related and that that's a bad use of the FTC Act, then the FTC will lose a lot of its enforcement availability for cybersecurity issues. But it also will probably have an effect on whether or not you can bring the franchisor into these lawsuits because of franchisee bad behavior. So just keep that in mind and keep an eye out for the determination of that case.
Thank you, Laura. Okay, next Jacob is going to talk to us about covenant of duty of good faith and fair dealing. I'm always interested in, as a transactional attorney, because I can't quite figure out.
Well, I'm not sure how much light I'm going to be able to shed on that, because the answer to what exactly that is a little bit nebulous depending on where you are. But let me ask y'all, how many of y'all think that in the state of Texas, the franchisor does owe a franchisee an obligation to act in good faith and to deal with them fairly? How many a few. And how many thinks they do not? Okay, well, it's very, very lawyerly answers, right? So my goal here today is to talk with y'all and just sort of highlight some of the issues so that when you leave here you can spot some of those issues, because not something we can really address in 10 minutes. And the case that I'm going to talk about not for the substantive proposition for which it stands, but just as a data point and how that differs from the case law in other jurisdictions and in the state of Texas. So the case I'm going to talk about is a Dunkin' Donuts case. And it was brought in Canada. 21 franchisees sued the franchisor, saying that the franchisor failed to support them, failed to support the brand, and as a result of that, over a 10-year period or so, the franchisees were just getting hammered. I mean, they were closing stores, they were losing a bunch of money. Meanwhile, in that same geographic area in Canada, a competitor came in and was just killing them. And so a competitor is doing very well. The competitor's franchise is supporting the franchisees, and the franchisees bring claims saying, hey, you know, you've got an obligation to support us more than you have, and it's an implied obligation that exists under the law. And so in that case, the trial court entered damages of $16.4 million and found that the franchisor, as a matter of law, had an obligation to protect the brand in that area, and that they did not satisfy that standard. Went up on appeal, appellate court affirmed for the legal proposition that the trial court awarded damages in favor of the franchisees for, knocked down the damages a little bit, but for the most part, the appellate court leaves that case intact. And so I highlight that because that's sort of a scary proposition if you're representing franchisors. It is a nebulous standard, and it's something that you need to be aware of. And I want you to think about that and then compare that to what the law is in Texas. Now, in Texas, there are only limited circumstances in which a franchisor will owe a franchisee that duty, that covenant, that obligation to act in good faith, and that obligation to deal with them fairly. And so I want to talk about, before I talk about what that duty is, I want to talk about where that duty can emanate from. There are express duties, right? So if it's in a franchise agreement, obviously, yeah, whatever jurisdiction it's in, it's a contract claim, that duty exists. I'm going to be talking about the implied duties for the entire time here today. And so the implied duties can arise from a couple sources, right? They can arise from a statute, they can arise from the common law, or they can arise from the relationship among the parties. And so what the courts say in Texas is the franchisors don't owe that duty. There are some certain narrow, limited exceptions to that, like there is with any good rule, right? And where there is it's essentially in Texas a fiduciary duty standard almost. So if you could establish an informal fiduciary duty, you could establish a special relationship of trust and confidence between the franchisor and the franchisee. There are courts that will find that duty exists from the franchisor to the franchisee. And I'm going to give you an example of a case where a Texas court found that duty did exist and was owed from the franchisor to the franchisee. It was a Taco Cabana case. The franchisee had brain cancer, was going through chemotherapy, was not as attentive to his franchise as you could expect he would normally be. It was devastating to his family, the petition says. And he talks to the franchisor, says, hey, here's what I'm going through, here's what's going on in my life. You know, I've got children, this is important to me. Franchisor says, handle your health, right? Take care of yourself, do what's important, and make sure that you handle that first. Well, franchisee misses some deadlines that he was required to comply with under the franchise agreement. Franchisor says, well, I'm going to hold you accountable for those missed deadlines. And the franchisee says, well, wait a minute, you told me to handle my health, you told me to do what I need to do for my family. You've got a special obligation because of those comments that you made to me, because of our pre-existing relationship. You've got an obligation of good faith and fair dealing. Franchisor files motion to dismiss the federal court case, and the court says, under those limited circumstances, and on that narrow fact pattern, that special relationship does arise because of the comments and the discussions that the franchisor had with the franchisee. Generally, it will not exist though. And so one of the things that's important in analyzing whether or not a claim can exist under this theory is to, first and foremost, to find out what state law you're going to be applying. Because in Texas is much more favorable to the franchisor than a number of other states. New Jersey recognizes the obligation as a matter of law. Minnesota recognizes the obligation. Illinois, Kentucky, they all recognize that a franchisor owes a franchisee that duty of good faith and fair dealing. And you really need to dive into exactly what that state's particular law is, because in certain circumstances it's limited. For instance, New Jersey, it's not just this broad sweeping duty of good faith and fair dealing. It's with respect to canceling or terminating or extending a franchise. So even the subject matter for which that duty may exist can be limited on a state-by-state basis. So the first thing you want to do is determine which state's law applies. And then once you figure out the state's law that is applicable, you got to determine what the standard is. And the standard is, and I understand why so many people are confused about the duty of good faith and fair dealing, because it's unbelievably nebulous. I mean, it really is a sort of a scary claim from the defense perspective, because it seems as though it's very fact intensive. It's not clearly defined. It's a gap filler claim where other claims don't exist. And so I don't really see a lot of value in discussing exactly what that is, because it is so different on a state-by-state basis, other than to say, generally speaking, what they all have in common is some sort of bad faith on the part of the franchisor, acting maliciously or acting in a way that would deprive the franchisee of receiving the benefits that they believe that they contracted for. One court said it requires each party to do all things reasonably contemplated by the contract's terms to accomplish its goals, and to refrain from doing anything that will destroy or injure another party's right to receive the fruits of the contract. Well, that's useless, right? I mean, that sounds a lot like a breach of contract claim. And that's what a lot of the courts say, because it really is a fact-intensive inquiry, and it does differ significantly by state. And so if there are a couple of takeaways from this discussion, I think it should be first, evaluate whether the duty exists. In order to do that, you got to look at the different, whether there's choice of law provision, what state you're going to be operating under, or what country's law you're going to be operating under. And then also, at least in Texas, when you're drafting your franchise agreements, Texas will honor a disclaimer of any implied duty of good faith and fair dealing. So if you say, look, specifically, there is no duty of good faith and fair dealing, under any circumstances, no fiduciary relationship, in Texas, the courts will say, yeah, look, there it is, right in the contract. But if you're in another jurisdiction, good luck. I mean, because some of them are much broader in the scope of that cause of action. So that's what I got.
Thank you, Jacob. Okay, so I am going to, I know we've all been hammered with the NLRB McDonald's action, but I feel like we would be remiss if we didn't talk about the joint employer liability issue in light of the Texas law that goes into effect on September 1st. So just as a recap on where we are with NLRB McDonald's, late last year in December, the NLRB authorized a little over 300 complaints to go forward against McDonald's as a joint employer with its franchisee on charges of unfair labor practices. In doing so, the NLRB pointed to McDonald's use of tools, resources, and technology to exercise, quote, sufficient control over its franchisees' operations beyond protection of the brand, and finding that the McDonald's was a joint employer with franchisees. The NLRB further pointed to McDonald's response to franchisees' employees' activities while participating in the fast food worker protests regarding wage issues and working conditions as further support for its position that McDonald's is in fact a joint employer with its franchisees. The consolidated hearings on the cases that are currently pending commenced in late March of this year, and the NLRB expects to issue a ruling in 2016 at some point. So that's kind of where we are with McDonald's, and I'm sure you all know the IFA has been extremely active in lobbying against the NLRB's proposed new standard for determining joint employer status, which would look at both direct and indirect control of the franchisor over the franchisee's business and operations, which is a much different standard than exists now. So Texas recently signed into law Senate Bill 652 that was filed by Senator Schwertner, who commented that the NLRB actions called the common understanding of the franchisor-franchisee relationship into question. And so Senate Bill 652, which, like I said, goes into effect September 1st, amends the Texas Labor Code to confirm that a franchisor is not considered an employer with respect to its franchisees or franchisees' employees for any purpose, including laws governing employment discrimination, wage and hour, minimum wage, professional employer organization, unemployment, workers' compensation, and workplace safety. So very positive news for Texas franchisors. The caveat of that, of course, is that it's limited and that it doesn't prevent employment claims if the franchisor exerts control that is, quote, not customarily exercised to protect the franchisor's trademark and brand. So it remains to be seen how this is actually going to play out in the courts, because we're not really sure at this juncture what the customary exercise of control to protect the trademark and brand is. We're all clear that franchisors need to protect their trademarks under the Lanham Act, and the FTC franchise rule and various state laws and regulations require the franchisors to exercise a certain amount of control over its franchise system in order to be a franchise. But where does that line, where is that line drawn as to what is too much control is still being fleshed out. So, but at least Texas has taken a position. I also noted the materials really more of just an illustrative point. Tennessee also passed a similar law that went into effect in April of this year in response to the NLRB attacks on the franchise model. And the Tennessee statute expressly states that franchisees' employees will not be considered employees of the franchisor for any purpose, absent a voluntary agreement between the U.S. Department of Labor and the franchisee. So those are just some legislative examples of positions that states have taken. The IFA is, in addition to its efforts against the NLRB's proposed new standard, is also heavily lobbying other states to pass similar statutes, kind of taking a stand on the franchisor-franchisee relationship. In the courts, we've also seen some pretty impactful decisions. The California Supreme Court in Patterson v. Domino's late last year also issued an opinion that was favorable for franchisors. In that case, the employee of a franchised Domino's Pizza unit filed an action against both the franchisee and Domino's Pizza, alleging that she was sexually harassed and assaulted at her job. The California Supreme Court concluded that the Court of Appeals erred in finding a tribal issue of fact of whether an employment relationship existed between Domino's and its franchisee's employee, because Domino's had no right or duty to control employment or personnel matters for its franchisees, and lacked contractual authority to manage the behavior of its franchisee's employees while those employees were performing their duties on their job. The court further noted that no reasonable inference could be drawn that Domino's retained or assumed any traditional right of general control over the employees. So no right to hire or fire or take any disciplinary action, no right to weigh in on scheduling, any of those things. And so, and even with the NLRB, we seem to be moving in a less scary position. As recently as April of this year, the NLRB again considered the relationship between a franchisor and franchisee. There was an advisory opinion that was issued in late April to determine whether nutritionality, which is a franchisee of Freshii, if Freshii was a joint employer with its franchisee, and a wrongful termination claim filed by two employees of the franchisee who were terminated for their involvement in union activities. And so in its memorandum, NLRB advised that Freshii, in fact, was not a joint employer with its franchisee under either the current standard, and this is what's important, or the proposed standard that's currently under review. And this I think we can take a little bit of encouragement from, that there is possibly some rational thought coming out of the NLRB now, because the franchise structure in in Freshie contains mandatory system standards and guidance on various human resources practices, such as hiring and scheduling of employees. The manual includes sample hiring advertisements, sample interview questions, a sample handbook that contains personnel policies. The franchisees are not required to use it, but some do. There was also evidence showing that some franchisees do not use it. And importantly, that Freshie didn't enforce any kind of requirement that the franchisees do use the employee handbooks or the employee policies that are provided in the operations manual. The franchise agreement specifically states that the standards don't include any personnel policies or procedures, and that the policies that are made available to the franchisees are optional. And the franchise agreement also expressly states that Freshie neither dictates nor controls any labor and employment matters for its franchisees or their employees. And then just with respect to general control over the business, Freshie is not distinct from, I think, most franchise systems where franchisees are required to use certain computer software and hardware, and there's not a requirement within Freshie system that every franchisee use the same POS. And so Freshie's monitoring of the franchisee's business is more passive, monitoring of sales transaction and stuff like that. But Freshie doesn't get involved into the the day-to-day scheduling of the franchisee's employees. So the NLRB found that the individual franchisees are exclusively responsible for hiring their own employees, setting their own employees' wages and their benefits. Again, like Patterson, responsible for any disciplinary action with respect to the employees, any hiring, termination of the employees. And so I think that the move that the NLRB appears to be making is in line with what makes sense and what makes sense for the franchise model. And so hopefully that will continue. I think this is the first positive thing we've seen from the NLRB since the McDonald's stuff started happening mid last year. Just as a plug for the ABA forum, I don't know how many of you typically attend the forum. I strongly advise you to attend this year. It's in New Orleans. The ABA governing committee has secured both the general counsel of the NLRB and David Weil, the administrator for the Department of Labor, to speak at a plenary session on just their opinions and their intentions with respect to this issue, which is huge for franchising, and their intentions, and I think it will be an incredibly useful session. As well as we've got, Jason is speaking in a session. We've got a number of Dallas attorneys speaking at sessions, which is great for us. And so, and a couple of Laura's colleagues are also, Maral Kilajan and Stephanie Ross are also speaking at sessions. So, so that's my plug for the forum. And thanks for your time. And I'm going to turn it back over to Jason to talk about non-competes.
Thank you. Me again. Thought it'd be dynamic if we sort of went back and forth a little bit. How's it working? I'm going to talk about non-compete agreements. One case, I'm going to go out of order in the two cases on your handouts. I'm going to talk about the small biz pros case because it's just so much fun. You should go read the small biz pros case. It's not that long. And I'll start with the lesson for this case. Those of us here who are the kind of lawyers that go to court always struggle with, well, I know my standards under the law that I have to meet, and I know that I need to put on evidence to meet those standards, but also my client doesn't have bottomless pockets, so how much money am I going to spend to invest to muster the facts to meet those standards? And I think that this case is kind of an interesting point on that. What they were going for is a preliminary injunction to enforce a non-compete. We could probably all recite together the standards for a preliminary injunction, but I'll just run through them. Substantially likely to succeed on the merits. There will be irreparable harm or The party will suffer irreparable injury if the injunction is denied. The threatened injury outweighs the injury to the opposing party will suffer under the injunction, and the injunction would not be adverse to the public interest. So let me jump into the facts of this case. This involved a tax preparation and bookkeeping business in Georgia. And a person who ran it named John A. Terrace. The A is important. That's going to come out in a minute. He said he came to the end of his term of his franchise agreement. The franchisor said, "Hey, John, you've been doing this for a long time. What do you think?" And John said, "You know what, guys? I'm just going to retire. I'm going to get out of business." They said, "Okay, great. Well, you have these duties under the agreement to help wind down your business, and also, of course, there's the non-compete. It's really fair. It's only a year. It's only for the town you live in. So we don't have these silly non-competes that you can't compete anywhere in the universe for the rest of time." John A. Terrace said, "Fine." Wouldn't you know it, almost immediately, John's wife opens up a tax preparation business with a name very similar to the one that was going before. And the franchisor, which was called Paget Business Services, sought a preliminary injunction to stop his wife from Mr. Terrace's wife from running this business. And Mr. Terrace's position was, "Hey, that's my wife, that's her business, it's her dream. She's always just wanted to run a bookkeeping business. But I gave her some advice on how to set up an LLC, and every now and then I come into the office to take my wife out to lunch. That's it." And so it's the franchisor's obligation now to muster the facts and see about whether Mr. Ferris is telling the truth. And that's where sort of the fun part comes in of reading this case, because he had a problem with the truth. So he gets on the stand, and the judge, who's writing this opinion, is very nonplussed by the testimony of Mr. Ferris, said it comes out in testimony that the website of this new business, his photo and his biography are prominently figured on the website as having experience in the bookkeeping and tax preparation business of 30 years and integral teammate. And Mr. Ferris testifies from the stand. Now, this hearing took place in the month of June. And he said, "Oh, well, you know what? I learned about that back in March, and I immediately told them that, hey, that's not right. Take that down." And so I took care of that. And so the judge, we're in the 21st century, folks. The judge has a computer at his bench, and he looks it up, and it's there during the hearing, which March and June are kind of far apart. Sorry. And so that's a big strike against Mr. Ferris. And then, so they have that hearing, and also it comes out that in addition to that, the franchisor had paid a private investigator to go to the office and with a little pinhole camera, like you see on the news, and talk to Mr. Ferris and actually have a session where he sits down and says, "Yeah, I'm running the show here, just blaze it down, that I'm in charge and I'll help you with your tax preparation business. I'm happy to do it." So that comes out too, I don't know what strike we're up to, I think about 19. But so then, the court takes it under advisement and writes the opinion later. So there's a period of time between that hearing and the opinion. And the court goes onto the website, and Mr. Ferris's biography and his picture have been deleted. But there's this new guy, John Alvin, who has appeared, no photo of course, but his biography is identical, a verbatim cut and paste of Mr. Ferris's biography. And the court says, "I can only conclude that John A. Ferris, that the A stands for Alvin." I mean, come on. So he finds that the standards have been met. And my sort of takeaway from this is, and he also talks about how Mr. Ferris's perjury will be treated on another day. The question is, if you're in that position and you just do you think that the franchisor needed to hire a private investigator in that situation? I mean, is the fact that this guy is just so demonstrably lying going to meet those 4 standards I just said? If your client's made of money, you should do that as a belt and suspenders thing, I suppose, but not all my clients are made of money. So it's kind of an interesting from that perspective, whether it's enough just to have somebody bald-faced lying to the judge in court would probably get you there for the purposes of a preliminary injunction. The other case is not nearly as fun. Acceleration Products versus Aerocoda. Really, I'm just going to touch on this for a second. This case involved a gym franchise, and the enforcement of a franchise. They're also seeking a preliminary injunction in this one, and it was in Arizona, and there were locations in or near Tempe and Scottsdale. And the franchise agreement had the non-compete had an addendum attached to it, and it had a very clear area, territory that the non-compete applied to, and it was just bright line drawing on a map, and so they sought their preliminary injunction based on these former franchisees who opened gyms in the greater Scottsdale and greater Tempe areas. But one was very clearly inside the black line on the territory attached to the non-compete agreement, and one was outside. Scottsdale was inside, Tempe was outside. And that made the difference, right? And not surprisingly, maybe to us lawyers. And so they said, okay, well, they can't compete. I'm going to enforce the preliminary injunction as to Scottsdale, but I'm not as to Tempe. You might meet these standards otherwise, that just on the other side of the line, they're opening that gym is hurting your business. But hey, you drew a nice bold black line, and they're outside that bold black line, and you're a sophisticated party who contracted with them, so suck it up. So it's an interesting thing to think about with just all what we struggle with as lawyers and drafting agreements is as you make things more specific, it makes it easier to enforce, the more specific maybe, but it also makes it easier to wiggle out of if they step just on the other side of the line that you drew so boldly in your document. So, thank you.
So I don't have any really salacious facts to share, but I do want to talk about the treatment of trademark counterfeit in the holdover franchisee context. It's on the last page of your lovely handout. But this seems to be gaining more and more traction, and if you are interested in it, there's a lot of articles that have been written about it, and it's been a continuing topic at the ABA Forum, and I think they talked about it briefly at the general session update at the IFA. So it is interesting, and it's worth looking into, especially if you're dealing with this situation in your system. So this specifically addresses the instance where you have a franchisee whose agreement has been terminated or not renewed, and the franchisee refuses to de-identify, and they're still operating their business using the marks. So traditionally, under the Lanham Act claims for trademark infringement, the franchisor is limited in the monetary damages that they can recover. They probably get an accounting of the profits and the actual damages, but they're only entitled to attorney's fees in exceptional circumstances. So the strength of that claim and the desire of your client to maybe go after it may or may not be strong. If you're able to succeed on the counterfeit claim, though, the damages are way better. You, absent extenuating circumstances, you're going to be able to recover 3 times the infringer's profits, or the trademark owner's damages, or statutory damages of up to $2 million, plus attorney's fees. So a counterfeit claim is way more interesting and enticing to you and a client than a traditional just trademark infringement claim. So there's a Century 21 case where there was a holdover franchisee who refused to de-identify and was still operating under the Century 21 brand. And in that case, they held that counterfeiting includes the use of a genuine mark on unauthorized services. So that was a big, step, because we went from goods to now including services in the idea of counterfeit. And now we have some more cases that are affirming that idea. Specifically, there was one in 2013 where the post-termination use of the O'Reilly's mark, which was federally registered, equaled counterfeiting. There are 3 elements to establishing counterfeit. It's the use of identical or substantially identical marks for goods and services covered by a registration, key being registration, and the use is unauthorized. So if you're in a system where you have a cantankerous franchisee who refuses to de-identify, maybe the counterfeit claim is something that you want to throw in your pleadings. All right.
We finished a little bit early. Any questions, thoughts, thoughts on any of the cases that we discussed today? Any thoughts on the Texas law that was just passed and whether that will really have an impact?
So I've got a very similar question. The first question we discussed with the licensee franchisor trying to prevent the stay of bankruptcy.
Yeah.
Why is the licensor franchisor trying to prevent the automatic stay?
Could you repeat the question?
Yeah, the question is just the dynamic between the franchisor and the franchisee in the automatic stay in a bankruptcy case. And I apologize if I didn't explain it clearly. Let me try again. The dynamic we're talking about is franchisee is the debtor. They file the bankruptcy case. And the automatic stay goes into place that prevents everybody, including the franchisor, from seeking to further any collection action or seeking to take possession of any property of the bankruptcy, the debtor's estate. And in that case, it was the reason they were seeking to lift the automatic stay in the Trump case was the franchisor was suing the franchisee in New Jersey state court. And the operation of the automatic stay stopped that, like it stops every case pending. And so in order for them to go forward and seek their rights under state law that the franchisee had breached that licensing agreement, they had to go run over, across the street and go to the bankruptcy court and say, look, here are the standards for us saying that the stay has gone into place, but it should be lifted as to us so that we can go, finish our business in New Jersey state court and hold these guys to account.
And it seemed like in that particular case, right, Trump was trying to pull back its license for trademarks and stuff. But of course, if that was allowed to happen, then there's not really much left.
Right, and that's true, and that's some courts weigh that heavier than others, because they were seeking to lift the stay to terminate the franchise agreement under its terms. They say that you guys didn't meet the quality standards. I didn't follow up on what happened. I imagine they worked it out. I think there's still Trump hotels and casinos in Atlantic City. I don't get there as often as I'd like, but I know that the licensor won that, but I don't think that they eventually just stopped them from being able to use the agreement, the intellectual property altogether.
Any other questions? I have gifts if you participate.
I'm not especially familiar with the McDonald's case. I don't typically do this area of law, but what kinds of things is the NLRB seizing on that is particularly alarming to franchisors with respect to determining joint employer status that are unusual, that are different from
Right, and I
traditional
think that that's part of the problem. I think that it's not entirely clear, and hopefully it will be clear what the specific criteria is that the LNRB considers definitively indicative of too much control versus, this is just in the wheelhouse of the franchisor protecting its trademarks and brand. And so what comes up in a lot of the discussions is the very obvious stuff. The franchisor, has control of the franchisee's employees, and and at first glance, this seems obvious, right? A franchisor can't go and hire and fire employees for the franchisees, but I think in practice, it's not always as clear. I was in-house before I went back to private practice, and I know that, from a practical standpoint, you've got these franchisees, and operationally you want to support them. And if you've got a franchisee who's not familiar with your business and is learning, and is not used to operating a restaurant and has been in some other business, and they're kind of figuring it out, and they're relying on you, franchisor, to help them. And one of the issues that they're having is controlling labor costs. And they're looking to franchisor to help them and guide them in how to control their labor cost. And so if you as franchisor are supporting them and giving them guidance on, this is how we manage labor costs in our corporate stores, And, and this is when we cut employees, when our sales drop below this level, and this is the kind of employee we look for, and this is the kind of employee we terminate. I think that that's where it becomes a little more gray, and I think that that's just it's gonna have to be fleshed out. I think Texas took a extremely positive step in taking a stand in the position with respect to the franchise model, because I do think it's really important that franchisors have confidence and security, and that they can control and manage their brand without worrying about becoming a target more than they already are for employee claims. It happens already. I mean, it's not like franchisors now are not getting sued by franchisees' employees. I mean, it just I think that depending on where the NLRB comes down, and the fact that Texas has passed a law will give franchisors a little bit more comfort level in that that they can continue to support the franchisees and operate the brand, and it gives at least franchisors in Texas something to rely on that's a little bit more definitive than kind of just waiting to see what happens with the NLRB.
Thanks.
Anything else? No. Thank you very much for your time. I appreciate it. And like I said, I hope to see all of you on August 6th at Bar Louie at 5 o'clock for the happy hour on negotiating franchise agreements. And then August 18th, we will have our regular noon meeting here on bankruptcy and loan workouts in the franchising context. So thanks very much, and enjoy the rest of your week.